Hello, welcome once again to Lehto's Law. I'm Steve Lehto. My friend Ed called me and told me about a disturbing case that came down last week from the Michigan Court of Appeals. And he said, "Have you seen this case yet?" And I said, "No." And he goes, "Oh, it's going to blow your mind. You're going to want to see this case." According to the Michigan Court of Appeals now, and this is a week-old ruling, mechanics in Michigan are allowed to charge you for work they did not do, even if it leaves your car in a dangerous condition and it injures you, and you cannot sue them under a law called the Motor Vehicle Service Repair Act, because although the law says that they're supposed to repair your car and so on and not do anything unfair or deceptive in dealing with you, what they call a repair is actually a little different than what you or I might think it is, according to the Court of Appeals. And like I said, this is a mind-boggler. This is a mind-boggler. This is the case in Michigan. This is not true anywhere else yet, thankfully. And maybe this goes up to the Michigan Supreme Court. Maybe somebody with common sense up there will understand how goofy this is. But this is possibly the worst opinion I've seen from a Michigan court, not my entire life, but it's in the top two or three. So the case is called Samuel Anaya versus Bettin Chevrolet. And I'll put the link to it below so you can read it. It's only a 7-page opinion. It's got some legalese in it, but it was issued on October 15th, 2019. And in the case, I'm just going to jump right into facts. In October of 2013, a plaintiff named Samuel Anaya and a woman named Doris Myrick's took Myrick's automobile to Bettin, and a place called Bettin Chevrolet, for service and maintenance. A service technician named Matt Root performed a tire rotation on the car, but did not properly tighten the lug nuts on the left front wheel of the vehicle. Now, this is important because this is not in dispute. The dealership didn't say, "We don't think that happened." The dealership admitted it. They said, "Yes, our guy forgot to tighten the lug nuts on at least one wheel. Forgot to tighten them. Forgot to tighten them. Sorry." So Myrick's drove away from Bettin, the dealership, with the plaintiff, Samuel Anaya, as the passenger. 2 blocks from the dealership, the left front wheel came off the vehicle crashed, hit a curb, and it injured the plaintiff. And that's why they're in court now, okay? So plaintiff filed a negligence action against defendants in 2017, alleging that they had breached their duties to properly perform vehicle maintenance when they rotated the tires and secured the tires to the vehicle, which caused him his injuries. Plaintiff later amended his complaint to additionally add a cause of action for a thing called the Motor Vehicle Service Repair Act. It's in the blue books behind me, MCL 257-1301. Trust me on that. The amended complaint did not identify a specific section of the Motor Vehicle Service Repair Act the defendants allegedly had violated. However, plaintiff later, before trial, filed a brief arguing they'd violated 2 sections, most notably MCL 257.1307A, because they charged for a repair that was not performed. So the allegation is, person brings a car in and goes, "Rotate the tires." They take the tires off, rotate them, put them back on, tighten 3 sets of lugs properly, and forget to tighten the 4th. They charge them for it, and then they drive off, and the accident ensues. And their argument is, you can't charge us because you failed to perform the repair. And it would be a violation of the Motor Vehicle Service Repair Act to charge for a promised repair that was not performed. That seems such a simple concept that it's going to blow your mind when you hear what our Court of Appeals did. And by our, I mean the state of Michigan. Before trial, defendants admitted that Root had rotated tires on the vehicle and had failed to properly tighten the lug nuts on its left front wheel, and they admitted they had breached their duty not to perform the tire rotation negligently. So that's written kind of awkwardly, but they had admitted they breached their duty to perform the tire rotation properly. They breached that duty. They argued about the causation, whether or not the accident caused this guy's injuries, and they also argued about damages, which everyone's going to do, but they held a trial. At the close of plaintiff's proofs, which is, the plaintiff puts in their case and the defendant puts in their case if necessary, halfway through the trial, defendants asked the court for a directed verdict. It's a common thing. You ask the court and you say, "Look, they didn't even put in a case. We should win." Now, here's the interesting thing. The court denied that motion, but then plaintiff argued that the evidence presented at trial demonstrated that defendants had misrepresented the tire rotation. They admitted they didn't do it properly. And since they failed to tighten the lug nuts on the wheel, there really is nothing else to try at this point. So the trial court granted the motion of the plaintiffs and gave them a directed verdict and said, well, they admit they did it wrong. What's there to try here? So then they basically had the jury just determine damages. The jury was instructed that defendants had violated the Motor Vehicle Service Repair Act and had admitted to negligence. So basically, it was a matter of just calculating a verdict if you think they're entitled to something. The jury returned a verdict in plaintiff's favor in the amount of $40,000. The jury's verdict form reflected its conclusion that defendants' negligence, that's one count, and violation of the Motor Vehicle Service Repair Act, second count, were proximate causes of plaintiff's injury, which means they're going to be liable for injuries if there are any. After the verdict, plaintiff moved for the entry of a judgment in his favor in the amount of the jury award plus penalty damages, because you can get those under the Motor Vehicle Service Repair Act if the actions are wanton and reckless. And the judge denied that. He said, well, the guy didn't tighten the lug nuts, but there's no evidence he did it on purpose or because he was, it very well could have been mere negligence, okay? Just the guy screwed up, okay? And the question is, do you get punished for a mere screw up? And under this statute, you don't. The judge did not grant that. So the judge did award $70,000 in attorney fees and court costs, but this thing went through a trial, so that makes sense as well. And the thing that's going on here is that if you file a claim for negligence and you win, you don't get your attorney fees compensated by the defendants. If you win under the Motor Vehicle Service Repair Act, you can ask the court to reimburse your attorney fees and court costs because you shouldn't have had to bring this case, and there's a statute that says you get your attorney fees back. So that's why they're arguing over this issue. So our Court of Appeals, unfortunately, oftentimes tries to find ways to strike down statutes that award attorney fees to prevailing plaintiffs. That's just the way they are. So I'm going to talk to you now about what happened here with the Court of Appeals. So they discuss how the courts can grant directed verdicts. That's understandable. But they say, after hearing both sides on appeal, we agree that the trial court heard two motions for directed verdict, and however, we think they granted the wrong one. And they say that the trial court shouldn't have granted a directed verdict to the plaintiff. They should have granted it to the defendants because the plaintiffs didn't put in enough proof to win, according to the Court of Appeals. And then they try to explain themselves. The purposes of the Motor Vehicle Service Repair Act include regulating the practice of servicing and repairing motor vehicles and prohibiting unfair and deceptive practices. Those are two different things. Unfair is one thing, deceptive is another. So if I'm deceptive, I try to trick you or fool you or scam you or something. Unfair can be a lot of things, including you just don't get what you paid for. So if I charge you for services I didn't do, that would be unfair. If I lied to you and said I did them when I know I didn't, that would be deceptive. Those things often overlap. But the point is that it's designed to prohibit both the unfair acts as well as the deceptive acts. And that's important because the court, I think, purposely tries to confuse these two to make it look like, well, it may have been unfair, but it wasn't deceptive. So again, they hammer on this and then they say, well, let's talk about the most important part here. MCL 257-1307A, which provides in relevant part, a motor vehicle repair facility that is subject to this act, no question that Bettin is, shall not do any of the following. A, charge for repairs that are in fact not performed, period. So you bring your car into a guy and say, do the tire rotation, and he gets most of the way through the job, but he stops before he's tightened the last set of lug nuts. Gives you the car back, takes your money, you drive off and crash. Were those repairs performed? Because it says if you charge for repairs that are in fact not performed, it's a violation of this act. No question. No question. Well, here's the problem. The Michigan Court of Appeals says that you and I misunderstand what the word performed means. You have to understand what the word performed means. And it doesn't mean what you think it does. In interpreting the word perform, as used in MCL 257-1307A, the trial court determined that defendants did not perform a tire rotation because they failed to tighten the lug nuts on at least one of the wheels on the vehicle. We disagree with that interpretation. Oh, okay. The primary goal of judicial interpretation of statutes is to ascertain and give effect to the legislature's intent. That's true. The legislature is presumed to have intended the meaning it plainly expressed. Again, true. How plain could it be that you charged me for work not performed and you didn't perform the work of tightening the lug nuts? Additionally, a statute must be read as a whole and in the context of the legislative scheme. When interpreting a specific term, such as perform, we consider its plain meaning and its placement and purpose in the statutory scheme. They're trying to make this sound more complicated than it is. Go find 100 people off the street and ask them, if I paid you to do the job and you didn't get all the way to the end and you charged me, had you performed? They'd say, no, of course not. Perform means that I'm going to finish the job appropriately or something. You did it. You did the job. The guy didn't tighten the lug nuts. That's part of the job. He didn't perform that part of the job. The Motor Vehicle Service and Repair Act does not define the term perform. So they say at that point, if it's not defined in statute, you go then with its plain language meaning, which is true. Okay? And they say, one definition we found, perform implies action that follows established patterns or procedures or fulfills agreed upon requirements and often connotes special skill. So when a mechanic is going to tighten the lug nuts in a car, you mean he might actually tighten the lug nuts on the car? The other definition he found says, perform means to carry out an action with no implication of actually finishing the action. So they hang their hat on the first one. And I'm not making this up. Therefore, the term perform generally refers to completion of an action according to an established procedure. The term does not imply that the action has been completed properly, successfully, or without mistake. So if I'm going to perform a task, I can stop halfway through and go, I've performed. Now, what's shocking about this, and people say, Steve, what don't you like about the legal system in America? And I am convinced that many courts on appeal and higher who have briefs brought in front of them on different topics all day long start losing track of the fact that the people they're ruling on, whose lives they're affecting, are actual people. I highly doubt that a Supreme Court justice or a Court of Appeals justice in Michigan actually has got to worry about taking his car in some place whether or not the guy tightens the lug nuts on it, okay? I don't know. It seems like more of a pedestrian thing that like you and I have got to worry about, but maybe not those people. I don't know. But the point is that for them to say the mechanic can get halfway through the job and stop, and you can't say he didn't perform. How about you simply look at the word perform as so often used, for instance, in the contractual setting, because they actually talk about what's performance in a contract. And that would have gotten you a better definition, because the idea that you can start something and stop without doing it would not be performance under a contract. But no. Instead, we'll go look at we'll go find 2 dictionaries we like, by the way, neither of which are blacks. We'll go find a couple dictionaries that we like and find one definition that doesn't say you've got to finish something to have performed it. The term perform, as used in the context by the legislature, does not support the conclusion that the repairs must be performed successfully or without error. Our review of the statute as a whole supports the conclusion that the legislature intended to regulate repair procedures and to ensure that customers were only charged for repairs that were necessary and were actually performed, as well as to protect an individual from unknowingly driving a vehicle repaired with substandard parts or unrepaired malfunction. That's what happened here. Okay? The repairs were not actually performed, and the car drove off with an unrepaired malfunction. So you go, wait, they're contradicting themselves. How do they get around this? Oh, I'll explain to you how. The language does not support the trial court's conclusion that a facility violates the act by performing a repair negligently. Indeed, such a conclusion would transform every negligent repair into a statutory violation. It's supposed to be. That's the whole point of the statute. If you bring your vehicle in for repair and they perform the repair negligently and it harms you, you should be allowed to get your money back, which is what the statute's designed to do. That's how everyone's understood the statute since it was passed, I believe, 40 or 50 years ago. Okay? This statute's been in the book forever as far as that goes. And the idea that someone came along now and said, oh, by the way, you don't have to actually complete the repairs to charge for them, and you don't have to do the repairs right to charge for them. This is crazy. So here they say that plaintiff alleged in his complaint that the mechanic had either failed to replace the lug nuts on one tire or failed to tighten them sufficiently, but that doesn't do it. That's not enough for a violation of the act. We conclude under the plain language of the statute that defendants performed a tire rotation albeit negligently. There is no support for the trial court's determination that a tire rotation is not performed if a service person fails to sufficiently tighten the lug nuts on the tire. To accept the trial court's interpretation would essentially turn every incorrectly performed repair into a violation of the motor vehicle. It's supposed to be. That's the point of the statute. We therefore reverse the trial court's grant of a directed verdict in favor of the plaintiff and remand for entry of an amended judgment. So they basically threw the award out and said, so they didn't tighten the lug nuts down. That's not a violation of any law. It's not a violation of the Service Repair Act, even though it says they can't charge you for work that's not performed. So following this logic, and I'm letting you guys know, for the mechanics in the audience in Michigan, if someone comes into your oil change shop today, you drain the oil out, you put new oil in, and you charge them, and they drive off and the engine explodes as they pull off the lot because you forgot to put the drain plug back in, they can't sue you under the Motor Vehicle Service Repair Act because you performed an oil change. You changed the oil. If somebody comes into your shop and says, I need to replace a head gasket, and you pull off the heads, you put on a new gasket, you put the old heads back on and forget to tighten the heads down or use a torque wrench, and the engine explodes and you go first to fire it up, you can charge them for the repair and say, that's your car, get it out of my lot. And when they say the car doesn't run, you go, I didn't promise to make the car run. I promised to replace your head gasket. And take a look, the head gasket's been replaced. That is the idiotic result of a case called Samuel Anaya versus Bettin Chevrolet, came down from the Michigan Court of Appeals last week. And I'm not exaggerating the impact of this. Right now, across Michigan, every mechanic, every car repair facility has just been given carte blanche to literally do horrible repairs, charge for them, and you have no recourse. Now, you could try to not pay for the bad repair if you can figure it out in advance, but then they'll put a mechanic's lien on your car. And guess what? The mechanic's lien says they get paid if they did the work. And according to this, they did the work. They just did it poorly. So, again, this has got to be the worst opinion that's come down in the time I've been doing my videos in the state of Michigan. It's the second or third worst opinion of all time in Michigan history. I hope the people on this case take it up on appeal. In fact, if you're working on this case, please call me. I've got some insights and there's some things you apparently missed here, but they don't really apply to how the court reasoned this through. Nobody could have seen this insane ruling coming. And in case you're curious about how agitated I'm getting right now, be assured that the Michigan court rules and rules of ethics prohibit me from saying what I really think. As an attorney, I am only allowed to go so far in criticizing the courts. So I'm going to tell you that in my opinion, this is a horrible opinion. I believe it should get overturned, but unfortunately, our Supreme Court is ideologically aligned the same way our courts of appeal are. But this ruling is absolutely absurd. And as I noted, right now, mechanics across Michigan, blank slate. Do bad work, doesn't matter. You can still charge your clients. Something bad happens, doesn't matter. Doesn't matter. The Motor Vehicle Service and Repair Act literally just got overturned by fiat, by a court, not the car company. A court simply going, we don't like the way that law works. We're going to change the word performed to mean something unlike anything anybody ever thought before. So there you go. Horrible, horrible opinion. Samuel Anaya versus Bettin Chevrolet. Questions, comments, put them below. I'll talk to you later.